There is a dataset in the National Archives that I have been working with for 3 years and have not been able to explain away. It is not a dramatic document. It is a spreadsheet, a modern one, compiled by a historical preservation survey in 1978, listing every county courthouse in the contiguous United States that was demolished between 1870 and 1930, and the approximate year in which the demolition occurred. The list contains 412 structures across 29 states, covering every size of county from the largest urban jurisdictions to single-road rural seats of government, spanning wooden frame structures and stone buildings alike. When I overlaid that list against a second data set, also in the National Archives, showing the counties in which federal courts had active Spanish or French colonial land grant litigation in the same period, something happened that I did not expect. The demolitions did not distribute randomly across the country. They did not follow population growth, or fire damage, or economic development, or any of the other proxies I tested against the list. They clustered. Counties with active colonial land grant cases demolished their pre-1870 courthouses at a rate more than 4 times higher than comparable counties without such cases, in a specific and bounded window between 1878 and 1901. 4 times higher. In a 23-year window, that is not a coincidence that geography or economics explains. It is a pattern that requires a cause. And when I went looking for the cause, I found a memo. I came to this the way I come to most things, sideways, through something I was not originally looking for. I had been researching the destruction of Spanish colonial land grant records in Texas and New Mexico, specifically trying to understand why so many Texas counties that had active grant litigation in the 1880s had courthouse fires in the same decade. Courthouse fires in 19th century America are common enough. Most early courthouses were wood frame structures without fire suppression. But the fires in grant litigation counties were occurring at a rate I could not account for through accident alone. A footnote in a 1912 Law Review article on Texas land title pointed me toward a different question. Not the fires, but the deliberate demolitions. Not the accidents, but the decisions. And the decisions, when I traced them backward from county commission minutes and state legislative records, kept arriving at the same federal program with the same administrative origin. One office. One mechanism. 400 buildings. By the time we reach the end of this, you will understand what was in those courthouses that made them inconvenient, what the funding mechanism was that replaced orders with incentives, and why the specific window of 1878 to 1901 corresponds precisely to the period in which the federal government was finalizing its disposition of the public domain. I want to be honest about what I am showing you. I am not showing you a conspiracy in the sense of secret meetings and explicit orders. What I am showing you is something more durable and harder to dismantle than a conspiracy. A system that achieved through financial incentives what an explicit order would have required too much accountability to sustain. The orders never came as orders. They came as money, and the conditions for receiving the money were structured so that only counties that had cleared their old records could qualify. The pre-1870 American courthouse was not merely a building. It was the primary repository of legal memory in the county it served. The place where deeds were recorded, where probate was established, where land grants were filed and surveyed and litigated, where the chain of title to every piece of property in the jurisdiction was documented from the first instrument of transfer to the present owner. In states that had been Spanish or French territory before American acquisition, Texas, New Mexico, California, Arizona, Louisiana, Mississippi, Florida, and most of the Midwest, that chain of title frequently extended back through colonial grant instruments that predated American sovereignty by decades or centuries. A Spanish land grant issued in 1790 to a ranching family in what is now South Texas created a chain of title that had to be acknowledged by American courts after the Treaty of Guadalupe Hidalgo in 1848, because the treaty explicitly guaranteed the property rights of those holding valid prior grants. The courthouse that held the document recording that grant was not just a building. It was the evidence. And evidence that cannot be produced in court cannot win a case. Consider what the General Land Office understood by the 1870s. The GLO was the federal agency responsible for the disposition of the public domain, the vast tracts of federal land that the government surveyed, sold, and granted to settlers, railroads, and states. Its authority depended on establishing that the land it disposed of was, in fact, federal land to dispose of. In states with prior colonial grants, that authority was regularly contested. A settler who received a federal land patent might find his property claimed by the heirs of a Spanish grantee whose original instrument was recorded in a county courthouse and who had never lost legal title under the terms of the applicable treaty. The GLO did not always win these cases. The Court of Private Land Claims, established in 1891 specifically to adjudicate colonial grant litigation in New Mexico, Colorado, Arizona, Nevada, Utah, and Wyoming, confirmed more than 2 million acres of Spanish and Mexican grant claims in its first decade of operation, acreage that came out of the federal domain and could not be repatented. Every confirmed grant was a precedent. Every precedent was a map that grant litigants in adjacent counties could follow. The persistence of colonial-era grant documents in county courthouses was not merely an administrative inconvenience to the GLO. It was an ongoing, compounding liability against the orderly and financially significant settlement of the public domain. By 1878, the cumulative value of land subject to active colonial grant claims in the affected states ran into the hundreds of millions of dollars in contemporary land values. That number had the attention of people who understood its implications. This is the part I keep returning to. Because in 1879, the General Land Office issued Circular No. 44. The circular is in the National Archives, Record Group 49, Records of the Bureau of Land Management, Circulars and Instructions Series. It is not a dramatic document. It concerns the standardization of land title recording procedures in states with prior colonial grant histories. Its operative language is administrative rather than aggressive. It informs county registrars that the GLO has established new standardized recording forms, and that instruments recorded in the older colonial-era formats will not be accepted as primary evidence in federal land court proceedings after January 1, 1883. County registrars who wish to ensure that their historic instruments remain legally operative are advised to transcribe them into the new standardized format. The circular then notes that federal technical assistance is available to counties undertaking this transcription work, and that counties which have modernized their record facilities will be eligible for assistance under a record standardization program administered through the Treasury Department's Comptroller General's Office. Read carefully. Circular No. 44 is not an order to destroy anything. Read carefully. It is a notice that instruments not in the new format will lose their legal standing, and that the way to avoid this outcome involves a modernization program administered by a specific federal office. What that notice accomplished, in practice, across the counties where colonial grant litigation was most active, is visible in the overlay of the two datasets. The mechanism was not the circular alone. In Record Group 217, Records of the Accounting Officers of the Department of the Treasury, there is a letter from Comptroller General J.M. Broadhead to the Secretary of the Interior, dated April 1882, describing the administration of what it calls the Courthouse Modernization Assistance, appropriation. The appropriation had been folded into a larger public buildings bill the previous year, at a level of funding sufficient to contribute meaningfully to county courthouse construction costs in the states of Texas, New Mexico, Arizona, Louisiana, and Florida. The eligibility conditions for accessing the appropriation, as Broadhead describes them, required that the county certify that its existing record facilities were inadequate for the modern administration of justice, that it had made arrangements for the preservation of all records in modernized format, and that the existing facility would be replaced. He does not use the word demolished. He does not need to. A county that accesses the modernization appropriation by certifying the inadequacy of its existing courthouse and then receives federal funds for the new building has no financial motive to maintain the old one. The old one comes down. What was in the old one, what was not transcribed, what was deteriorated, what was in a language the new county clerk did not read, does not come down with it into the new facility. And that is where the colonial land grant records went. Not into the flames of dramatic courthouse fires, in most cases. Into the gap between what was transcribed and what was not. Into the pile of instruments that a county clerk in 1885 decided were too deteriorated to copy accurately, or too legally arcane to bother with, or too politically complicated to preserve when the new courthouse was waiting. The 1978 Preservation Survey that produced the dataset I have been working from contains a secondary finding that appears in its appendix and is not mentioned in its summary. In 37 of the 412 demolished courthouses, researchers who investigated county land records after 1930 found gaps in title chains that could not be explained by the recorded history of the property. Gaps that corresponded, in each case, to the pre-1870 courthouse demolition, and that in each case had been resolved by federal land court decisions issued in the decade following the demolition. Decisions that in every instance found for the party holding the federal patent rather than the party asserting the colonial grant. Every one. In every case where a gap in the pre-1870 title chain resulted from a courthouse demolition in the target period, the federal court found for the federal patent. Not because the judges were corrupt. Because the evidence was gone. You cannot win a case on a document that no longer exists, and the court cannot acknowledge a right it cannot examine. The legal standard for establishing a colonial land grant in federal court required production of the original instrument, or a certified copy made at or near the time of the original filing, a transcription made in the 1880s by a county clerk who may not have read Spanish and who was working from a deteriorated original under time pressure, into a standardized American format that was designed for a different kind of instrument, did not meet that standard. The gap was not just the absence of a document. It was the destruction of the specific form in which the document was legally operative. You could know a grant had existed. You could have secondary evidence, family records, land use patterns going back generations. None of it met the evidentiary threshold. And the evidentiary threshold had been set by the glow. Consider the scale of what this meant on the ground. In South Texas alone, the acreage subject to Spanish and Mexican land grant claims at the time of the Treaty of Guadalupe Hidalgo has been estimated at over 21 million acres. The litigation over those claims continued for decades after the treaty. By the time the relevant county courthouses had been modernized, their pre-1870 record facilities replaced under the terms of the federal assistance appropriation, the documentary basis for a significant fraction of those claims had been thinned considerably. Not eliminated in every case. Thinned, some records were transcribed accurately. Some were partially transcribed. Some were not transcribed at all and do not appear in the new facilities. The acreage that changed hands in federal land court decisions during and immediately after the demolition window, acreage where prior grant claims had been active, and where the courthouse was demolished in the relevant period, amounts across the affected states to a number that has not been formally calculated and whose calculation I am not in a position to complete from the available records. But the individual cases are documented. The pattern of the individual cases is visible in the overlay, and the overlay is not ambiguous. This was not limited to the American Southwest and South. The same administrative logic, that records not in the approved format would not be credited in federal proceedings, that modernization assistance was available to jurisdictions that cleared their old facilities, that the resolution of gaps in the title record defaulted to the most recent valid American instrument, operated wherever the United States acquired territory with a prior property regime. In Hawaii, after annexation in 1898, the records of the Hawaiian Kingdom's Bureau of Conveyances, which documented land title under the Great Mahele Land Division of 1848, the kingdom's own systematic land distribution, were subject to a federal standardization program requiring transcription into American formats. The transcription was incomplete, conducted under time pressure, and without sufficient staff who could read the kingdom's land records accurately. The gaps resulting from the incomplete transcription were resolved in federal court in favor of the territorial government in every case that reached judgment. Native Hawaiian land claims that could not be documented in the surviving transcription record were extinguished. In Puerto Rico, after 1898, Spanish colonial property records were subject to similar standardization requirements, and losses from incomplete transcription were similarly resolved in favor of the American administration. In the Philippines, in Guam, in the Virgin Islands after 1917, the pattern repeated: prior land records, prior land rights, a standardization program that the prior rights could not fully survive, and a federal court standard that the surviving documentation could not meet. The mechanism that operated through courthouse demolitions in the continental United States operated through transcription pressure in the territories. The administrative logic was identical. The outcome was the same. What could not be produced in court could not prevail in court. What was in those 412 courthouses was not only architecture and not only history. It was the documentary foundation of property in America. The instruments by which people who had been on the land before the American state arrived had established their legal relationship to it. Spanish land grants issued to cattle ranching families in South Texas in the 1790s. French colonial land concessions in Louisiana that predated American sovereignty by 50 years. British colonial patents in the Southeast that the Treaty of Paris had guaranteed and that American courts were required to honor. Community land grants in New Mexico that had been maintained by Acequia communities for generations and that documented not individual title but collective rights to water and pasture. Probate records establishing inheritance chains going back 4 and 5 generations. Records of manumission and land purchase by formerly enslaved people who had acquired property in the decades before the Civil War and whose title depended on instruments in those buildings. When those instruments were not transcribed, or were transcribed inaccurately, or were lost in the transition from the old building to the new one, the chain of title broke. And a broken chain of title, in American property law, is resolved in favor of whoever can produce the most recent valid instrument. In the states affected by the modernization program, that instrument was the federal patent. The federal patent was issued by the General Land Office, the same office that issued Circular No. 44. The same office that administered the evidentiary standard against which the old instruments were measured and found inadequate. The same office whose administrative successor holds the land title records for the public domain to this day. The 412 buildings are gone. Many of them were genuinely deteriorated, genuinely inadequate, genuinely in need of replacement. That is not in question. What is in question is whether the pattern of their replacement, clustered in counties with active colonial grant litigation, funded through a federal mechanism whose eligibility conditions required the demolition of the previous facility, producing title gaps that were uniformly resolved in federal court in favor of the federal patent, was accidental. And when I put the 4 data sets next to each other, the demolition list, the grant litigation map, the Broadhead letter with its eligibility conditions, and the post-demolition court decisions, I have not been able to find an explanation for the pattern that does not involve intent. Not dramatic intent. Not a room full of men deciding to steal the land. Structural intent, embedded in the design of a funding mechanism by people who understood exactly what the eligibility conditions would produce and designed them that way. The memos are in the National Archives. The overlay is reproducible. The court decisions are on record in the federal district courts of the affected states. What is not on record is a public accounting of what the mechanism accomplished across its 23-year operational window. That accounting has not been attempted, because attempting it requires holding 4 data sets in the same room at the same time, and the 4 data sets have been in 4 different record groups in the National Archives: ARG 49, ARG 217, ARG 121, and the 1978 Preservation Survey, which is not a federal record at all, but a historic American Building Survey publication, since the last of them was compiled. If this is something you need to share it with someone who believes that property law is neutral and that records loss is accidental. Because the records that are gone in a specific pattern, and the pattern has a source, and the source left a paper trail that has been sitting in 4 different filing systems, uncombined, for more than 100 years.